thank you all so much. I'm going to take a slightly different approach. I won't summarize everything everyone said because we all heard this and we're all very good listeners. So let me put my spin on what I've heard, not just from our panelists, but throughout the session so far. We're talking about ensuring equal access to justice for all. And what I've heard is that it starts with zealous advocacy throughout. So that begins with the public itself, before people come into contact with the law. So that means awareness raising, explanation in languages that the people, whoever they may be, understand. It also includes advocacy in terms of the investigation. It means with the legislators in setting up the systems and having legal aid law. It means at the trial. It means post-trial in appellate processes. It means also with social workers. Particular strategies that I've heard today from my panelists include collaboration. That was an issue that was raised yesterday. Stakeholder roundtables. Get the key actors, the duty bearers, around the table to begin to discuss from the beginning. If it's a new system and we're looking at establishing legal aid, get the key duty bearer stakeholders around the table, including the bar associations, including the judges, the police, the prison, the legislatures. Get them around so that they can have a buy-in. The next thing I've heard is we need to collect baseline data. Baseline data. And we need to monitor. If there is already a system, then we need to monitor what's going on to ensure that the services that need to be provided are being provided. And if there are glitches in the system, we're identifying them and then can come up with a solution for addressing them. Once we have the baseline, we should look at piloting to see what works, to have a record of success. Or if they're not successes, we can then, before we launch it nationwide, we can develop strategies to address the glitches in the pilot. We should also look at mitigation. Mitigation. I thought it was a very interesting point about the women and ensuring that, and I'm going to come back to who I have heard are the all in the all, ensuring access to justice for all. Do we understand our clients? Who are our clients? We can't argue mitigation at pre-trial or even at trial if we don't understand the circumstances of our clients. So are our clients migrants? Are they committing offenses coming into contact because of who they are? What circumstances they are being confronted with? In the United States, there was a case, and it strikes me, it was called the burning bed defense. That was a case where, I won't go into details, but it became a self-defense case for women who were subject to abuse over long terms. So through zealous advocacy by a lawyer, they changed and brought in a new defense that never existed before because they understood who the client was and the circumstances under which they behaved in a certain way. I also hear, again, zealous advocacy throughout. One of the things I haven't heard our panelists talk about, and perhaps you as participants will talk about on the all, I've heard all being women, being migrants, being members of certain ethnic groups, and the panel have discussed different ethnic groups. But what about children? I'm sure there are participants here whose organizations look at the special interests and needs of children who come in conflict with the law. The last thing is client awareness. At all times, who is your client and what are their circumstances at contact, at trial, and within the within the penal system. So right now I'm going to open the floor to questions, comments, and actually we're looking for strategies. What have you confronted and how have you addressed it? Please, Mike. And because in my law school, we believed in the Socratic method, and I have a list of all of the participants. I'll begin to call on different countries. So I encourage you.
Okay. I'm Shahbaz Jamal. I'm from Iraq, working for UNDP. Actually, my question is about the interaction of legal aid institution and the legal aid provider with what is called informal justice system, actually. Especially when it comes to ensuring the equal access to legal aid and to the justice system, because we all know in the communities that we have a strong informal justice system. In most cases, they are using their own traditions and customs to solve problems between members of this community. And in most cases, these traditions are not according to the international standard or even according to the domestic laws in this society. So my question, what is the best approach, any idea about the best approach, how we can approach this system, informal justice system, to ensure equal access of the member of such community to the justice system and to the legal aid, especially the vulnerable group, because in such community, especially women, we talked about the women, they have very limited access to justice system, even to communication means actually to reach the formal justice system and the legal aid. Thank you.
Thank you. Mary, please.
Michele Washington from UNDP. I wanted to make a quick comment. I just want to make a quick comment responding to what Andrea mentioned on the impact of the war against drugs on women and actually all drug users. And in fact, today is the International Day Against Drugs, and the key message of this day is that drug abuse is treatable and preventable. Our approach is that drug abuse should be treated as a health disorder, and there is a lot of literature on our website on this issue, and I think one strategy is really providing dedicated legal aid for those people when they are in detention and ensuring that they actually get treatment and not sanctions. Thank you.
Thank you, Mary. Oh, great. So I don't have to call on people. In the back row, please. I'll just take, since this was a comment, I'll take 3 more questions or comments and then open the floor again.
Yes, thank you. My name is Mimi Mamga. I'm a practicing attorney from South Africa. I'm also a representative of the Law Society of South Africa. When we talk about ensuring equal access to justice for all, the focus seems to be more on ensuring justice for people who are accused, for people who are the defendants. But I think we seem to forget that we must also include the victims of crimes and the witnesses as well. The emphasis shouldn't, if we're going to say that we're ensuring equal access to everyone, victims are, as well need to have access to justice. They need assistance from the legal aid. In the process of the trial, they need someone there to help them. The prosecution may be there, but the prosecution is focused on prosecuting their case. What about the rights of the witnesses and the victims that have been violated in the process? I think we should also focus our attention there, as well as people with disabilities. We should not forget about those people when we talk about access to justice, that they also enjoy similar rights under our Constitution and similar protection. Thank you.
I'm Megan Waters from the West African Law Institute, and I just wanted to follow up on the first gentleman's question and sort of ask your opinion as to what the role of lawyers is in dealing with the sort of social stigmas that go. As the first gentleman mentioned, I think that there are a lot of issues with the women who are facing the judicial system are generally sort of sent there by their families or their communities, and they're sort of shunned from communities. So what, if any, do you think the responsibility of lawyers is in to sort of breaking down those social stigmas, or in the case of a particular client, how do you deal with that if, let's say, you get the woman acquitted? How do you kind of deal with the fact that her community is not willing to re-accept her into it?
So right now, I think the first question was on, I'm not going to say informal, I'm going to say traditional justice systems. And what happens when, or how do we ensure that they're aligned with the domestic principles and international principles and standards as well, if I'm understanding the question. The second is on how do you advocate for mitigation, understanding your clients. The third is on victims, witnesses, and ensuring that consideration for them are a part of ensuring equal access to justice for all. People with disabilities, and how then do lawyers argue mitigating factors as it relates to women, and what, if anything, can be done to ensure that they're being eased back into society is a little bit easier. Any other panelists, please?
I'm just going to respond to three aspects. The first one on informal justice, I'm just going to give what we've done in our country. What's being done, especially under Just Centers Uganda, they have identified communities which have strong roots when it comes to the informal justice system. They have picked the opinion leaders, they have picked the community leaders, and they have passed on information which is basic, which takes into consideration the international elements and the domestic elements. And these people, they have also created a team within these communities to pass over or to increase the advocacy on the key elements whenever they choose to opt for the traditional mechanism. And it's working. It has somehow improved on the way cases were coming from, especially the Muslims and some communities which have that element. And I think we can try it. And in my presentation, that's why I said there's more emphasis at the village entry level, legal aid provision, and the monitoring. Then there was also an issue with the stigma, that how do we deal with somebody who has passed through the system? In my country, under legal aid, they are providing legal counseling. And they try community reintegration. And what does this involve? The person who had the name of an ex-offender, the name it's like a ritual where that person gets rid of that bad name to get back into society. And they support these people over a period of time, even under community service, so that these people settle back into the community. And the victims, when the process of reintegration, the victims are much, much involved, so that there's this social cohesion, so that is minimized. And the last one, on what happens, I also mentioned in the presentation about the monitoring level. What happens in court? How are these people being treated? This is when issues are picked, are passed over to the court user committees or the district chain committees, and then issues are addressed. I think that's all I can give.
If I may just come back in on the traditional justice issue, though I'm in UNDP Liberia right now, one of the things that we worked on in southern Sudan at the time, was actually we worked in cooperation with DPKO, the UN mission in Sudan at the time, in ensuring that we respected very much their traditional systems and understood that the people, particularly in post-conflict settings, went to the traditional authorities because they had always been there. So we worked with training the traditional authorities on the domestic principles and the international principles to bring them along to ensure that as they administer justice, if you will, that they were being capacitated over a period of time to ensure that they understood their domestic law and the international principles. I would invite any other colleagues to speak about what has happened in the traditional to ensure that the people are having access to justice even in the traditional systems. And then again, I want to open the floor to speak about children Are there any organizations here or institutions that are dealing with ensuring that children who come in conflict with the law are being given the best service and the best representation? Please.
I want to talk about children and early access to justice using an example from New York City. We learned about 10 years ago that children were being arrested in our schools for doing things like writing on the desk, or being late to class, or cursing, using foul language. And recently there have been a lot of conversations in New York City about helping children who are in the criminal justice system. And I advocated very strongly that, yes, we need to have positive supports for kids in the criminal justice system, but it is far more important and will be a much more important victory if we can keep our children out of the criminal justice system. Every child who is arrested for anything is a defeat for our society. So we have fought to reform our policies, to end the practices of police being in our school, arresting kids for things that should be dealt with by educators, and ensuring that children, for example, who identify themselves as gay or lesbian are not harassed by police when they're driven from their homes and living on the streets, which often happens when their families abandon them. So I think, defense lawyers, legal aid providers are in a unique position because the cases that come before us tell us what's going on in our societies. And we have an obligation to identify the patterns so that we can be effective advocates for systemic changes that will help ensure the freedom and liberties of all of our members of our communities and lighten our caseloads at the same time. Thank you.
We have two more comments from the panelists.
Merci encore une fois. Bon, en Guinée-Bissau, la question de la justice traditionnelle est très importante, puisque, par exemple, il y a la plupart de la justice qui est faite en Guinée-Bissau est faite au niveau de la justice traditionnelle. Mais il y a des communautés locales qui font de justice traditionnelle, par exemple au niveau de droit d'héritage, et que, par exemple, bon, c'est le neveu qui hérite quelqu'un qui est, par exemple, décédé, pas les fils, les enfants de la personne décédée. Bon, de plus en plus, il y a des recours qui après sont faits au niveau des tribunaux de l'État, et qu'à ce niveau-là, les décisions qui sont prises par les tribunaux de l'État vont contre les solutions qui sont adoptées au niveau de la justice traditionnelle. Donc il faut faire en sorte que la justice traditionnelle corresponde au niveau de ces décisions et de ces procédures, corresponde à ce qui est établi au niveau de la loi de l'État. Bon, les cliniques juridiques qui sont créées en Guinée-Bissau et qui fonctionnent ont un rôle très important auprès des autorités traditionnelles. Ils leur soutiennent dans le sens qu'ils essayent de faire en sorte de contribuer à ce que toutes ces décisions qui sont prises au niveau de la justice traditionnelle correspondent à ce qui est prévu dans la loi, de façon à éviter le choc entre la justice traditionnelle et la justice qui est ministrée par les tribunaux de l'État. Donc, les cliniques juridiques ont un rôle très important à jouer à ce niveau-là pour apporter des changements nécessaires de façon à permettre l'harmonisation entre, dans certains aspects, entre la justice traditionnelle et la justice de l'État. Nous avons pas mal de conflits entre les tribunaux et les autorités traditionnelles qui font la justice. Il y a pas mal de conflits que l'État est prêt appelé à essayer de régler.
I'm afraid I won't be able to do justice to all the vulnerable groups we haven't discussed, but I couldn't live with no reaction to the persons with disability questions, so let me just say a few words about that. I think here we have to differentiate whether we talk about representation in a, let me say, regular criminal justice process, or whether we're talking about the sad fact that very often communities and families are not able or willing to deal with disabilities, and therefore prisons are used, let me say, as a dumping ground for persons that communities cannot handle. And so the situation of legal representation here would be a very different one. Also, disabilities, of course, we're talking about a super wide range, physical, mental, learning disabilities, and the responses here would be very different. So I think there would be a need for more time to be dedicated to properly address this. And for children, let me just say that some of the factors we heard about in a workshop on the first day was very interesting. Of course, here as well you have the developmental capacity of the question of how do you reach out to guardians, to parents. You have to talk to children in a different way in order to make them understand what's happening to them. And we had a very compelling speaker who described how intimidating the justice system is, even for adults, and even more so is it for children. So also for this group, more time would be needed to discuss this properly.
Can I have?
Just after Wendy, please, we have one more question. I'm being given the sign to summarize and finish.
I think this works. Okay. Yeah, I think there's very good comments and questions. When we talk about effective legal aid, it does not only mean we have the legal service. It also means the remedy channels to choice. For example, for migrant workers, all the cases we will go through the negotiation and mediation. We will all try these efforts first, because first this type of cases lack of evidence, and usually they are in a familiar circle like friends or town fellows, and also they have small amount of money. If you go through the judicial procedure, it will be very complicated. So we use all these kind of cases. We will go through the negotiation first, and then the mediation. So almost 1/4 or 1/3 of all cases settled through negotiation or mediation. Second is, when I talk about the model as an experiment, I shared with you it can be replicated geographically, but it also can be replicated to other areas like women's rights. We have extended to women's rights in 2012 and a criminal legal aid in 2011. For the criminal legal aid, not just for the defendant, but also for the victims, especially for sexual cases. As to the children's rights, I shared a little bit at the beginning. My organization, Beijing Children's Legal Aid Research Center, is the first Chinese non-profit organization on children's legal aid research. We have collaborated with the Supreme Court and the National Committee on Women and Children's Rights to promote the juvenile justice. And also it has a very quick development actually in China now. We have the juvenile tribunals. We have worked on 2 important projects. One is the reintegration, responding for the children who can be sent to community to learn something, and then they can get a job. And also we have another program for the victim protection. So if they cannot get any compensation from the offender, so we'll try to respond to help them to get treatment or reintegration. So I just share a little bit here.
I'm going to take one final question from the floor. This is from Nicole.
Thank you.
Comment.
Thank you. I just wanted to talk a little bit about what is happening in our West Bank office. Nearly half of the cases that we represent in our West Bank office are juveniles. And over the last year in Palestine, or particularly the West Bank, there's been a push, particularly for juveniles who've been arrested, to provide them services that are in the best interest of the child. But what we found is that the best interest of the child does not take into consideration the juvenile's right to counsel, the juvenile's right to be free from illegal detention. And so what happens is at police stations, instead of having a lawyer come and talk to these juveniles, they're actually sending social workers. And the social worker then decides whether or not the juvenile needs a lawyer. And so the juvenile's right to counsel is actually hinging on whether or not this particular social worker on this particular day thinks the juvenile needs it. And also there is this kind of propensity, or this, sometimes courts will hold juveniles in custody for their protection. And so instead of working to find alternatives to juveniles, safe houses, etc., courts are choosing to hold juveniles in custody, which is a clear violation of their rights to be free from arbitrary detention and illegal detention. And so what we've tried to do at the ILF is, one, train our lawyers to be at police stations, to access the juveniles where they are when they're arrested, but also we work with stakeholders to emphasize that you cannot, best interest of the child does not exist in a vacuum, just like the right to counsel does not exist in a vacuum. And so we have to figure out ways to, mesh the two in order to provide the best services for juveniles, particularly during early access. I'll stop. Sorry.
Thank you. I'm going to invite us all. We've heard so many issues, and we all face, both in developing, conflict, and post-conflict countries, a variety of challenges. And we're given just a small amount of time to discuss the strategies. I invite us all to think about different strategies that have worked, could work, and share them vis-a-vis the email, using the emails with our organizers, so that perhaps as an additional outcome to this, we'll have additional strategies. Even if we don't have the time right now, please take the time, give some consideration to some of the issues that are raised. We're all experienced, and we're experiencing new things, so let's share our experiences using the internet. And I think it was Dr. Horowitz who mentioned this, to continue this sort of cooperation and collaboration, not just domestically, but internationally, and using all of us to ensure that we bring access to justice for all of our clients. I thank you, and before I just step away, I have two more tasks. First is to share a gift from our organizers with each of the panelists.